Are you going through a property settlement and want to protect yourself? Do you need to decide whether to do a consent order or a BFA? Well, today's episode is going to be perfect for you. We're going to talk about how to ensure that your property settlement is legally enforceable and the difference between a consent order and a BFA. And we're also going to talk about concerns people have or worried that their ex may come back and have future claims and how you can avoid that. Welcome, Mum.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
This is a question, Mum, we get asked a lot, a lot. And we just did some webinars recently, and it was a very frequently asked question. So let's just hit it on the head. First of all, Mum, let's talk about what a consent order is, and then we're going to talk about what a binding financial agreement is. Can you just explain really quickly, what is a consent order?
A consent order is an order that you ask the court to make, but you both sign it and you both say to the court, we've already agreed, will you just please make this order? And the registrar has a look at it. If it's just and equitable or in the best interests of the kids, they'll stamp it and send it back to you and the order's done and you don't have to go to court.
Okay, brilliant. So that's for anyone, maybe you go through mediation or you're negotiating by yourself. That's what a consent order is.
Yep.
Okay, so what's a binding financial agreement?
Okay, well, they no longer call them binding financial agreements. They're just called financial agreements. And as I always say, there's a warning right there. But BFAs has entered into the popular language of financial advisors and people at the banks, and everyone wants a BFA. The difference between it and a consent order is profound. So a binding financial agreement, or financial agreement as they're now known, is a written document in the form of a deed that you both would sign formally, saying this is how we want our property settlement to go and we don't want any involvement of the court.
Right. Okay. So what's the difference then? I guess I can already see a glaring difference between a consent order and a BFA.
Well, the consent order, the court runs their eye over it and seals it, like puts a stamp on it, and you've got your answer. They can be overturned, but not easily. Okay. Most people don't bother trying to overturn a consent order. A financial agreement, on the other hand, is often something that people have entered into probably before they're married, but if they're, or their relationship or after their relationship, whether it sticks or not, whether it holds or not, depends very much on the quality of the legal advice that each party gets. So they're a lot more expensive, and you actually don't find out if they work, if you've done them as a prenup, until you need them. You need it. So there are a lot of cases about trying to overturn unfair financial agreements that were used as a prenup.
Do you need lawyers more in a BFA than you do in a consent order, or is it about the same?
No. You don't need lawyers at all for a consent order. The court lets you file those by yourself. With a financial agreement, it is not valid unless lawyers have given you certain advice and certified that they've given you certain advice. So It's a lot dearer, a financial agreement.
So let me just get my head around this. So a consent order is an agreement between you two based on roughly the Family Law Act, making sure it's fair. You file it in the court. The court says, yes, this is fair, stamps it, and that's your agreement. A BFA, you get written up by lawyers.
Yes.
And the court never checks it. It doesn't have to be fair, and it can be signed. And can I ask one really stupid question?
It's not stupid.
Do you need both?
No.
Okay.
You can only cover. With the consent order for property settlement, it needs to range over all of your property and deal with your property one and done. With the financial agreement, that financial agreement, it's also the only current one at the time. You can't have a couple on the run. Okay. Yeah.
When is it best to choose a consent order over a fight like BFA?
I think I'm a big cheerleader for consent orders. And if the registrar rejects it and says this isn't fair, then you get an opportunity to fix it up then. With the financial agreement, the court has said we can't stop people making bad bargains. If you want a third person, maybe to bind a third person, you can do that in a financial agreement. But generally, and this is from my experience, financial agreements are often used where one person is at a disadvantage. And those are the cases like Kennedy and Thorne and Kennedy, where the more powerful person kind of pressures the least powerful person or the weaker person to signing something to their detriment.
Right. Okay. So, Mum, we have done an episode on consent orders. Do I really need them? And go and listen to that episode if you're still up in the air going, oh, I'm not sure. But just in a nutshell, what's the risk of not having either of these?
Well, for children's matters, I guess you're just not clear where you stand, but you might be able to do a parenting plan. And many people never have orders about the kids.
Yeah.
If you don't do a consent order for property settlement, ever since the case of Farmer and Bramley, which I think was a 1991 case, you run a risk of someone later on saying, you know what, I'll have my property settlement now that your house is worth $2 million, now that you've inherited the money, now that you've won lottery, now I'll have my property settlement. So it kind of draws a line under the relationship, and everything that happens from there on is yours, and you can set your life up accordingly.
Right. So again, go and listen to that episode. And Mum's just name dropped a couple of cases, and I don't know if any of them, but we do have a Patreon account where Mum has cases explained by Lynn, and she goes through these cases and talks about what the judge or what the appeals court or whatever court ruled and why. So if you're interested in those cases, you can go and join our Patreon and go and listen to those episodes. So, Mum, how can an approved consent order protect you from future claims? How does it protect you?
Well, you only have one property settlement each. You don't have a right to keep going back to court to tweak it. So it's finalising your relationship. And as long as everyone is honest, as long as you've been honest in your side of the application and they've been honest in theirs, it's done, and it can't really be overturned easily. You hardly ever see them overturned.
How does a BFA or a financial agreement, because they're not called binding, how does that protect you from future claims?
Well, you can put maintenance orders in there and protect yourself a little bit, but the reality is it's only as good as it is once it's tested by the court. And so in the case of Thorne and Kennedy and Thorne, that went all the way to the High Court of Australia because the stakes were very high. One person was very, very wealthy. And so it was worth having a try at it. I think with financial agreements, you can do the best you can and have your lawyers, follow our guidelines to the letter, but it doesn't stop the other person having a go if they think they can overturn it. Okay.
How many times do you see people having goes at trying to overturn financial agreements?
I probably hear about one every couple of months.
Oh, wow.
Yeah.
How often do you hear people having a go at trying to overturn consent orders?
Not as often at all, because people have signed it, they've agreed, they've lodged it. You can't appeal consent orders unless you do it in the first 30 days. So it's kind of gone through the process of the court and people arrange their lives accordingly. But the feeling that I have with the financial agreement is that because the court hasn't run their eye over it, the whole thing gets looked at again. And you could get a nasty surprise. I heard someone recently whose lawyer said, don't get a consent order because the registrars might requisition it and you'll have to do other things. And as I explained to this person, well, if you got a financial agreement and it didn't work, you won't find out until you need it to work. So, I'm a big fan of consent orders, but I understand some things just need a financial agreement, and I've done them myself. They're very dear, though. They're very dear.
Oh, true. So difference in price?
Yeah, a lot. Because our insurers want us, they know that if a financial agreement fails, for instance, right, wealthy person does a financial agreement, the lawyer acts for them, and the other person overturns it, the first thing the wealthy person is going to do is sue their lawyer for it not sticking, okay? And so our insurers work this out pretty quickly. And the number of precedent letters and things we have to sign and so forth to make sure they're watertight is amazing. And if you miss a step, that might not be something satisfactory to the court, and they may go, no, the whole thing's out.
So it's super expensive.
It's dear.
Can you give me in Australia what's an average price for a BFA? Depending on what law firm or state you're in.
I'd say somewhere between $7,000 and $20,000. I know.
Okay.
I know.
And it's not even called binding anymore. That's terrifying.
Yes.
How much does consent orders cost these days with lawyers?
It's just a few $100s to file the document in the court, and you don't need a lawyer. You can do it yourself.
So in our course, we show you how you can do it yourself.
Yes.
How much would it cost to get a lawyer to write up consent orders?
If you'd already agreed, probably $3,000 to $5,000, maybe less than that. It depends on the amount of detail in your agreement, so that there's not that many more questions to ask or argue over. Yeah.
Okay.
So basically, a financial agreement is expensive because what it's trying to do is massive. It's saying to the family court, Commonwealth government, stay out of our business. And to effect that, the lawyers have to really be careful to dot every I, cross every T, and our insurers are on our back. And so that all costs money.
Right. Can you think of a time when a BFA may be better than consent orders for someone?
Yep. If you want a third person involved, right? Say, for instance, your mother, not me. Say one of the parents of one of the kids owed some money to the parties and you wanted them to be locked in to paying it to a particular party. You can put that in a financial agreement, and that person, the mother, has to sign it as well, and everyone agrees to be bound. So there's a lot more scope in a financial agreement. Yeah, but they still worry me because overwhelmingly it's used by a stronger party against a weaker party.
Yeah.
And a lot of the cases, ones that where they overturn them or try to overturn them, are ones where the person was under so much pressure leading up to a wedding or birth of a child or something that they really, as Judge Demack said, they really had no choice but to sign it. And that's your case in Kennedy and Thorne, something like that. And the High Court, the full court said, no, a deal's a deal. And then the High Court said, no, it was unfair because that person had no right, no other options. So you have to look at when you sign it. If it's a prenup, you can't sign it too close to a wedding. If it's a prenup and you get married, is it going to last past the wedding? So there's a lot of technical issues. So I think what I'd say to people is if you want to do a financial agreement, you really need a family law specialist, an accredited family law specialist, because otherwise you'll always wonder if it's going to hold or not.
Let's talk about the process of getting the financial agreement, not binding.
Yes.
So to get it to stick, because you talked about it can get overturned if one of these steps is done. What is the process to get it to stick?
Okay. So first of all, each of you has to have a different lawyer. Okay. And one person's lawyer will generally draft the agreement or the proposed agreement in the form of a deed. And then we'll send it across to the other person's lawyer, and they will then maybe make some changes or ask for some changes to be made or some deletions. And each party goes back and forth. In addition to the deal that's being brokered between two people, the lawyers are also negotiating to get to a level of comfort that that the agreement is comprehensive and it can't come back and bite them. So it's two-pronged. So you can't say to your lawyer, just do me a rough, quick BFA or financial agreement. I don't care. Just put it in. No, it doesn't have to be that long. Just leave all that out. No, you can't. So there's two sorts of agenda going on there. And if you're separating, then there's also a negotiation going on as well about how much and when and all of that. And if it's a prenup, it's awkward because it is still a negotiated outcome between the lawyers. And I guess it's a bit hard to keep the romance alive in the lead up. Yes.
Yeah. Look, to be fair, Mum, most of the people who will be listening because they're on their way out of a relationship.
Well,
but hopefully they all will learn that moving forwards, if they're going to get into a new relationship, that a BFA. And we do have a really good episode on how to protect yourself after divorce.
Yeah, you do. I always say that to my clients. You've struggled hard and you've got your share of property. Before you go into a new relationship, seriously consider getting a prenup, which is a financial agreement.
Okay. You both go and see different lawyers. Somebody writes it up. Each of you have a different lawyer. Each lawyer gives a letter of advice saying, this is a good deal, this is a bad deal.
Yep.
and then you sign it. There's no filing it in court. It's just a thing. It's a contract.
Just is. It has to be delivered to someone. Someone gets the original, and the lawyers have to keep the files forever and ever in case there's ructions later on.
Right. Okay. All right. So that's the BFA process. Oh, and then you pay, $35,000 to the lawyers.
Whatever it's cost to negotiate the deal. And the higher the stakes, I guess, the more careful people are.
Let's talk about the process of getting consent orders approved and created. And you want to just make sure you point out that consent orders can't be used for prenup.
No.
This is for the end process.
This
is for when you are getting a property settlement. So how do they go about it, Mum?
Okay, so let's assume you've agreed, okay? We always encourage people, don't we, Laura, to go and see a lawyer to make sure that what you're getting is fair, that you've considered every option. Let's say then you want to do your own consent orders. So the application for consent orders, each party fills in their side. It's literally one side for the applicant, one side for the respondent. And so it doesn't matter if you don't agree on some of the things because you're just swearing that your side is true, your application is true, and they're saying their side is true. So you both have that sign those documents before witnesses, and the consent orders are basically attached to the application to the court, and they need to be each signed on the bottom of each page.
Just to check, the consent orders basically are saying he gets this much percentage or she gets this much, or the car is going to be transferred into this person's name, the house is going to be transferred to this. So it's really
or
just
the house,
who gets what.
Yeah, absolutely. The house is going to be sold and he's going to give the fridge back and she's going to give his golf clubs back, and who gets what, who pays what money. So it just sets out all of the things that you're going to do to reach and to finish everything between you. And so you put all of that in, you sign it, and then you file the application in the court. So everything in the family court starts with an application. That's why a financial agreement doesn't involve the court, because they never apply to the court. So you have an application. If you're going to have a huge row or you don't know if you're going to agree, you still start with an application. And the difference between consent orders application and the others is, here's the application. Oh, and these are the orders we've agreed and we would like you to make. And so that means the court doesn't have to make any decisions about values and things like that. What they do, though, is they look through it and only can make the orders if they perceive them to be just and equitable.
And so they don't meet you, you don't go to court, you just file it on the portal, and you do that once you've come to the agreement. So you're putting the start in and you're putting the stop in all at once.
Good job, yes. But I don't think I'd like to say that you never go to court, because sometimes the registrar's like scratching their head going, what's this mean? And they may ask you to come to court to explain. Or they may get call that a mention. If they're not sure on something or if they want to make a comment on something. And sure, sometimes registrars don't understand, or they don't think it's reasonable. And so they'll write back, and that's this requisition. Write back and say, can you explain this a bit more, or how come this is fair?
How often does that happen?
Well, it is happening a bit more now because the courts merged, as you know, and they've begun to have these specialist registrars, and a couple of them do all of the consent orders pretty well Australia-wide, because there had been a situation where each state, like each registry, Brisbane might be different to Rocky, and Lismore might be different to Sydney, whatever. And so they're trying to harmonise it. And these registrars pretty well do nothing but consent orders. And so they have very clear and specific requirements that they must address. But I think that's a good thing. Wouldn't you rather know before the orders were made, rather than do a financial agreement and then find out down the track it wasn't good? But of course, financial agreements are not concerned with being fair. Only a consent order has to be fair.
How does the court know if it's just and equitable? How do they figure that out?
Well, I said in the application, you've got the applicant fills in one side, the respondent fills in the other, and they put in their assets, they put in what they say their contribution was, and the registrar can clearly see how they've worked it out. And sometimes there might be $30,000 or $40,000 difference to what may be a usual division of property in a certain case. But a lot of the time when you have to do a letter of justice and equity that goes with it. And in that one, a lot of people can say, look, it's not exactly what we wanted, but in the interests of certainty and we don't want the delay or the expense of going to court, so we've made a commercial decision. Yeah. So the registrar looks at the sections of the Act just like a judge would and sees if you've satisfied that. So Section 79 for property.
And let everybody know that we have done countless videos of that Act and countless explanations of the property considerations that they do make in court and a registrar would make for consent orders. And we also have done countless videos on how to create your consent orders. So I don't know if anyone's aware, but at the moment, as of it's February 18th, we've got our DIY divorce blueprint open. If you are looking to create your property consent orders, jump on our course, become a member, and you can start doing that today and watch all those videos and figure all that out yourself. We also have the Q&As too, so if you get stuck, you can come along and ask questions. But shameless plug, I've just done that, Mum. Moving forwards, I could show you we don't show you how to do financial agreements. We show you how to do consent orders. Yeah.
But Laura, also, the law is changing on property settlement, and as of the 10th of June, and as an additional shameless plug, I want people to know we are updating that section. So the day the new law comes in, that's the day the section will be updated. And we've done some talks, I think, on the proposed changes.
If you're interested in learning about the proposed changes that are coming, and they're really exciting,
yes,
I'll put a link in the show notes to that episode. We did it a couple of months ago.
Yeah.
Okay, let's talk about the common pitfalls and how to avoid them. Relying on an informal agreement is a disaster.
Well, it's no agreement at all, really, isn't it? I think, though, if you leave your possessions with whom they are, like say it was a short relationship or you always kept your money separate, then the court does have to consider if it's just and equitable to make any sort of property order. So it is it's okay if you can't avoid it, but it's kind of hanging over your head, and it's better even if you do an affidavit or orders that say we'll each keep what we've got.
Yeah.
Finished.
And we show you how to do that in the course as well.
Yeah.
Mum, what about failing to disclose all the assets? What if you're trying to get consent orders or financial agreement and there's just that you're applying for it, but all the assets haven't been disclosed? Can that be a problem later?
Yeah. If you think that all the assets haven't been disclosed, then if you're going into consent orders, you're kind of relying on what the other person has said. And that can be an occasion coming up, like further on down the track, if you discover they had things that you didn't know, to overturn those consent orders on the basis of misrepresentation and failure to disclose.
So you can overturn a consent order if, like, one day you're just like, oh, I've only got this house and this car and that's all. So you do the consent orders. And then a month later, they're driving a Ferrari and sailing the Whitsundays and going overseas. Yeah. And you're like, wait, where did that money come from?
Well, I wouldn't want people to get the wrong idea, because that's a really hard application to win, okay? And it would involve a forensic examination of where that money came from. And the court is really reluctant to kind of what they call open the floodgates by giving people a second bite of the cherry. So if you're not sure what assets there are, maybe a consent order is not for you. If you're confident that you know all of it and then get kind of blindsided later on, that may be a different story. Go and see a lawyer. And
with financial agreements, you don't need to know what all the assets are.
With financial agreements, some people say that they have enough knowledge of their ex's finances to not need disclosure. And many lawyers will choke at that and say, well, I can't really help you with that because I want full disclosure, so I know what advice to give you. Okay. And other lawyers give you a big long letter about how you should find out what assets there are and recommending that you go to court and so forth if that's what the option is. And you may give your lawyer in writing instructions, and I would suggest a big waiver of liability to not pursue the issue of disclosure. And sometimes, call you what?
Call me crazy, but I think it would be crazy, or there must be some other reason that needs to be looked at as to why someone would want to enter a financial agreement or a consent order if they don't know everything. And I know we've talked about non-disclosure, and we've got a great episode on that. And we're not talking about every little cent.
No.
But we're talking about if there's a whole section, a whole amount just missing. I mean, I can see why some people just throw their hands up and go, well, forget it, I'm done, I don't care, I just want this over. But really think hard, I guess I'm saying, before you sign anything if you don't have enough disclosure.
That's right. Sometimes nothing is better than a bad document. But Laura, I'm sorry to say, but over the years, I've come across people who are in a coercively controlling relationship, and that coercion continues post-separation. Or they may enter a property settlement agreement because the other person will then let them have the kids more. So there's all these sort of things working on them.
You've gone into our next pitfall there, Mark.
Oh, dear.
And that is signing under pressure or coercion. So what happens to people who sign a financial agreement or a consent order under coercion? Because I have heard people who are just desperate. They care about the kid's situation and they're not going to give in for that, but they need money to live on. And so they just go, fine, just give me that small amount because it's better than nothing. Or they say, if you don't sign this, I'm going to take the kids. Or if you don't sign that, I'm going to do X, Y, Z. So when it comes to either of those, is there anything that they can do, or what should people be looking out for?
I think the Family Law Act has been drafted to protect people as best it can. And if you're at that point of just signing it so you can get some money to live on, I think you need to go and see another lawyer, get a couple more opinions, consider whether you can get spousal maintenance instead, because people aren't supposed to use their property settlement for living expenses. That's not right. That's not fair. I think that with the financial agreement, you may do that. You may say, oh, I'll just sign it no matter what. But your lawyer has an obligation to make sure you're in a reasonable frame of mind as well. Right. It's so hard. But I think spousal maintenance would be a better option.
We've got a great episode called Spousal Maintenance, Am I Eligible? We've also got another episode on spousal maintenance, How to Apply. And both of those, if they're dangling a carrot over here and you're desperate, the great thing about spousal maintenance is they have to then pay you until property settlement, and it puts the screws on them. So that's something to consider. Yeah. Now, Mum, the other thing is, not the other pitfall that people fall into this is, and I know we offer a DIY how to do it, but we always say go and see a lawyer before you get it signed. Yeah. So, Mum, not getting proper legal advice is really risky.
That's right. If you educate yourself, I think that gives you a little bit of protection, and that's why we always say we're educating, empowering and equipping people. But if you don't know, then you don't know that you don't know. And if your lawyer doesn't tell you or hasn't picked up on it or doesn't know, then you can merrily go down a path of completely detrimental to you. So if you feel any nervousness about whether your lawyer is across everything or not, or if your gut says that surely that can't be right, then go and see someone else. Get a second opinion. You tell the lawyer that you see second that you don't want them to contact your initial lawyer. I suggest go and get some formal advice, perhaps from an accredited specialist, to find out, because the court has ways of helping people, but only if they ask the right questions.
So definitely make sure you're getting the right legal advice. We have people writing in all the time or speaking to you, Mum, where the lawyers said something that's completely ridiculous and not anywhere near what the Family Law Act says. So it's happening out there. So make sure you're seeing the right kind of lawyer and a lawyer with the right knowledge. And there's great lawyers out there, but there are also some duds.
Well, I think you can't dabble in family law anymore. You either do family law or you don't. And my way with family law is you do it boots and all. And those people, if your lawyers, if you're getting a second opinion, or even if you're quizzing your current lawyer, ask them what the amendments are that are coming in on the 10th of June this year, because that's significant. Those changes are massive. And although I don't want to go into them all now, but it's to do with a person's behaviour through the marriage. It's to do with wastage, gambling. It's to do with what you've done since separation. It's just kind of fixed it up, I think. And it's the biggest change since 1975, with all due respect to the government.
Yes. Now, so let's just quickly talk about the common pitfalls again. So we've said relying on informal agreements where there's nothing written down is very risky because that can be disputed later. And go and look at the case of Farmer and Bramley. Then we've got failing to disclose all the assets. If there's no full transparency, the risks involved there, be aware of them. Not getting proper legal advice is risky. So signing anything without any guidance, risky. And then signing under pressure or coercion, also risky. If there's an unbalance there, if there's someone really powerful, the other person isn't, there's a reason that you should be thinking before signing. Now, Mum, big question everyone's going to want to know. What happens if someone wants to challenge the settlement? How do they get consent orders reopened? And how do they get BFAs overturned?
Okay, so both of them involve an application to the court to overturn previous orders or to overturn the previous agreement. And the court will then forensically go through and see if they should overturn for example, the BFA. They'll look at the technicalities, they'll look at the reality, although they say they're not there you can have a bad agreement, it just has to be set out properly. And then you will either fail or succeed on that. With consent orders, it's quite a massive thing to overturn consent orders because they've been approved by the court. And it would only be if there was something came up and you'd been misled. And then the court will probably reopen it. But guess what? They open it and look at the assets as they are on the day that they review your property settlement. So if you're wanting to overturn some consent orders, but you've done really well since separation, then the case of Woodland and Todd says that the assets have to be valued as at the day that the court's making that decision. But yes, so both involve going to the court and both involve the court overturning, getting rid of the previous consent or the financial agreement, and then exercising their discretion and following the law as it is on the day to get new orders.
How long does that usually take?
It can take a long time. It can take a year. And I think Kennedy and Thorne, because it went from, one judge to the full court to the high court, it was a year or two, I thought. So, okay. But now, the risk is if you don't succeed, then you may well find yourself paying the legal fees of the other person.
Yikes.
Yeah.
Yeah. So you got to do it properly and you got to do it well.
And I think you need a barrister's advice before you would embark on trying to overturn any sort of agreement. You need to have a legal team. Yeah.
Mum, a lot of people write in about this one as well, and we don't touch on it very much because we kind of focus on the lead up to property settlement and finalising it, and then we say, you're done.
Yeah.
But people write in and they say, I've got a financial agreement. I've got property consent orders. My ex isn't doing what they're supposed to be doing. So what can people do who are listening today and sadly, I think we're going to miss a lot of them because it'll be people trying to figure out BFAs or consent orders. But what can you do if your ex doesn't follow the agreement?
Well, they're both enforceable in the court, but it's a struggle. But yes, you take them back to court either for a contravention application, which is very technical, and I don't recommend you do that on your own, or you go for an enforcement order. And if for some reason the orders, like one of the ways you can overturn consent orders, if they're impracticable, but they really have to be not practical anymore, not just because one person doesn't cooperate, then the court may change the orders, but generally they will try to follow the orders and compensate a person in a different way. And that's why it's so important that every order specifies who has to do something, what they have to do, and the time frame when they have to do it, and what happens if they don't. So very well drafted orders will always have kind of an or else or a default thing, which then clicks over into, then it's automatic that you follow through. So that's the aim, I guess, of orders, is to anticipate issues. One of the things about consent orders that you can put in an order that a registrar of the court could sign a document that your ex refuses to sign. 106A, I think it is. And if you've got, say, a house sale going on and your ex disappears or refuses to sign, well, you go, that's fine. You go to the registry and you go, she won't sign it, and the registrar has the power to sign it if that's pursuant to the orders. So
Brilliant.
yeah,
Okay.
and also with I meant to say before with spousal maintenance, and this isn't as relevant here, but just remember, if you get an order for spousal maintenance, even if it's consent, the child support agency can collect that for you along with your child support, and that makes them pay. They can do collect.
Okay, so that's good to know that if you've gotten your consent orders, what happens, when it's going to happen, and what should happen if it doesn't happen. Because I've heard horrible stories of like they're supposed to sell the shares and then divide it up, and the ex is like, "Well, I've lost my password, so I can't sell the shares," or all these kind of yucky tactics at the end. So if you have those kind of people, make sure you've got that locked in. Mum, finally, what kind of questions should people be asking themselves when deciding between a BFA and a consent order?
I think I go this way. Why can't it be a consent order? Why shouldn't it be a consent order? Okay.
Right.
It's the cheaper option. The court runs their eye over it. It's the kind of basic and even into high-end property settlement. Why can't it be a consent order? And if your lawyer's saying financial agreement, ask them why can't it be a consent order?
Right.
And
Brilliant.
you might have, and the answers are probably beyond the scope of this talk, but if your lawyer can put it in writing, why then you can consider your position. I think whenever you come to a crossroads like this, if you're not clear, if you don't think they're explaining it properly, ask them to give you a letter of advice about it. And then you know. Yeah.
So getting it right now
Yes.
and making sure whatever the orders are written properly and well are going to save you money in the future. The same with it not doing anything and maybe them coming for you later. It's going to save you money in the future if you sort it out and get it done and do it right now. And I know that a lot of you out there are overwhelmed, and just the choice between this and that. Maybe your ex has said, let's do a BFA, because it seems to be the thing that flies around now. People just say it like it's
it's
ask,
a trend.
and do what Mum said. Ask yourself, why a binding financial agreement? Because they're not binding anymore. Why a financial agreement? Why can't we just do a consent order? And really look into it and make educated decisions. Yes, you may be a little bit overwhelmed right now. You just have to make little decisions and take little steps. You don't have to do it all in 1 week. Okay. I don't think I've seen anyone do consent orders in 1 week.
Don't be rushed. Actually, Laura, if I had to say something to anyone, it's don't be rushed. Don't be hurried. Don't be rushed. And the big takeaway for me from years of practice is that orders can look absolutely spot on, beautifully formatted. They do all the things you want it to do. The court may even pass those orders, make the orders. And yet when you look into it, they're not clear and there's ambiguity and there's argument. So even if you think you've got the best orders in the world, even if you've used our course and put plug and play, go and get a lawyer to run their eye over it. Make sure it says what you think it says and it does what you think it does.
Yeah. Just a reminder to everybody, there are those two options. It's pretty clear Mum isn't a big fan of the financial agreement.
I've done lots, but I don't share.
Mum does do them or did do them, but she's not a fan of them. And I don't want anyone to be, when Mum talks about those time limits, be pressured. Okay. You always ask, why are they pressuring me? Why is there a time limit?
And also, though, you mustn't forget, though, listeners, that there are time limits from a divorce and from de facto time limits. So a year from the divorce, 2 years after separation de facto, and there may be a dispute as to when you separated. The person doesn't want to hand anything over, usually says you separated much earlier. So there's a lot there to unpack and you need some legal advice. Yeah.
When Mum talks about those time limits, she's meaning you can't file in court without special permission if you've gone 2 years from breaking up and leaving your de facto relationship, or if you've gone 1 year from official divorce paperwork. So
that's right.
Great news if you've just been separated but you're still married, then you don't have a time limit yet.
But the divorce.
It's de facto that really is the kicker. Those people that ask that question a lot, and I hope if you are facing this right now that you go and educate yourself, go and learn about the process. It does make it less scary, and it does sometimes. I felt like, to me, when I was going to get my property settlement, I felt like I was walking into the Wizard of Oz office and it was a big Wizard of Oz sitting there. And I'm like, "Ooh." And then I didn't understand anything. It made no sense. And of course it was terrifying. And I was agreeing because I didn't understand things. So once I started to learn it, now I get it. The Wizard of Oz is actually just a person who just knows the Family Law Act. And you don't even have to know it like backwards to forwards. But if you at least understand it to a small degree, you can go and listen to some of our property settlement episodes. We do some great ones on contributions, future needs, all of that. How does it work? Go and listen to those and just get your head around it. So when you're Dorothy walking into the law firm, the Wizard of Oz is not going to be that scary.
And it's not a substitute for legal advice, but it just gives you that parameter. And this isn't a substitute for legal advice, but at least you'll know the difference now.
That's right. Thank you, Mum, for your time today. And good luck, everyone, in making your choices.
All the best. Bye, darling. Bye, Rose.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.